In Canada, a life sentence doesn't always mean life. Parole is a possibility, bail is a right, and the justice system is built on a delicate balance between punishment, rehabilitation, and the rights of every single person, even the most condemned. But what happens when that balance is shattered by unspeakable acts? We're looking at the violent crimes that sparked such intense public outrage. They led to historic and sometimes controversial changes in how Canada punishes its most dangerous criminals. These are the stories of the murders that forced Canada to change its laws. It begins on a filthy, sprawling pig farm in Port Coquitlam, British Columbia, a place that, for years, hid a secret of unimaginable horror. This wasn't just the scene of a crime. It was a graveyard. The man who ran it, Robert Willie Pickton, would go down in history as one of the most prolific and grotesque serial killers of our time. The sheer scale of his depravity was one shock. But the second shock, the one that would challenge the entire Canadian legal system, came after his conviction. Despite being linked to the deaths of dozens of women, the law, as it stood, meant he could be eligible for parole in just 25 years. That single fact would ignite a firestorm and kick off a decade-long battle over the very meaning of a life sentence in Canada. To understand the legal earthquake Robert Pickton caused, you have to understand the man and the sheer scale of his crimes. For years, women had been disappearing from Vancouver's downtown east side, a neighborhood plagued by poverty, addiction, and systemic neglect. They were vulnerable, often involved in sex work, and overwhelmingly indigenous. They were mothers, daughters, and sisters, and they were vanishing. For a long time, the police response was tragically inadequate. Families begged for help, for investigations, for answers, but their pleas were often dismissed. The women were seen as high risk, their disappearances not a priority. This inaction allowed a predator to operate right under everyone's noses. That predator was Robert Pickton. He used his chaotic, muddy pig farm as a personal hunting ground, luring women from the downtown east side with promises of money and drugs. There, he subjected them to unimaginable violence before murdering them. When police finally raided the farm in 2002, what they uncovered was a macabre scene of industrial-scale slaughter. They found human remains, DNA, and personal items belonging to dozens of missing women. Pickton himself was later caught on an undercover video, boasting to a cellmate that he'd killed 49 women and was just sloppy for not making it an even 50. The trial was a legal marathon. In 2007, Pickton was convicted of 6 counts of second-degree murder. The Crown had 20 other first-degree murder charges ready to go, but they were stayed. Why? Because Pickton had already received the maximum possible sentence under Canadian law for second-degree murder. Life in prison with no chance of parole for 25 years. Legally, it was the exact same sentence he would have gotten for first-degree murder. So another long, expensive trial was deemed unnecessary. For the victims' families and a horrified Canadian public, this was impossible to stomach. 6 murders confirmed, 20 more charged, a confession to 49, and his parole clock was set at just 25 years. The public outcry was immediate and visceral. How could a man responsible for a mountain of death be given any hope of release? How could the sentences for each life he took not be added together? This is where the legal system at the time comes into play. In Canada, sentences for multiple crimes were almost always served concurrently, meaning all at the same time. If you were convicted of 6 murders, you didn't serve 6 25-year parole ineligibility periods back to back. You served 1. The clock started on all of them at once. For the families of Marnie Frey, Serena Abbotsway, Mona Wilson, and the other women Pickton was convicted of murdering. This felt like a slap in the face. It suggested that after the first murder, the others were somehow free. Legally, there was no extra punishment in terms of parole time. The public fury found a receptive ear in Stephen Harper's conservative government. The Pickton case became the poster child for their tough-on-crime agenda, seen as the ultimate loophole in a system that allowed a mass murderer to be treated, for sentencing purposes, as if he'd only killed once. While there were broader concerns about sentencing for multiple murderers, Pickton was the undisputed catalyst for change. This pressure led to the Protecting Canadians by ending sentence discounts for Multiple Murders Act in 2011. This law was a direct response to the Pickton case. It gave judges a new power, the ability to stack parole ineligibility periods one after the other. For the first time, a judge could decide that if an offender killed 2 people, their parole ineligibility could be 50 years. For 3 people, 75 years. If this law had existed for Pickton, he could have theoretically faced a parole ineligibility of 150 years, a sentence that actually meant life. The era of the volume discount for murder was seemingly over. For about 11 years, this was the new reality. The law was used in a limited number of high-profile cases, with judges handing down sentences of 50 or 75 years, ensuring society's most dangerous killers would die behind bars. The law seemed to have closed the Pickton loophole. And then came another crime. On January 29, 2017, a man named Alexandre Bissonnette walked into the Islamic Cultural Center of Quebec City and opened fire on the worshippers inside, murdering 6 men in a hateful act of terrorism. He pleaded guilty to 6 counts of first-degree murder. The Crown invoked the 2011 law, the one born from the Pickton case, and asked the judge to stack the sentences. 6 murders, 25 years each, for 150 years without parole. But Bissonnette's lawyers fought back, arguing the law was unconstitutional. They claimed that a sentence offering 0 hope of release, no matter how much someone changes over decades, is cruel and unusual punishment. And that right is protected by Section 12 of Canada's Charter of Rights and Freedoms. The case went all the way to the Supreme Court of Canada. In a stunning, unanimous decision in 2022, the court agreed. They struck down the law. The court's reasoning was profound and, for many, deeply controversial. Chief Justice Richard Wagner argued that a sentence isn't just about punishment. It has to include the possibility of rehabilitation. A sentence that condemns a person to die in prison with absolutely no realistic hope of parole, no matter what, is intrinsically incompatible with human dignity. It crushes all hope and negates the very purpose of rehabilitation. The court found that such a sentence is so absurd, it could bring the justice system into disrepute. The backlash was immediate. Politicians who had championed the law were furious. Victims' groups felt betrayed. It looked like the highest court in the land had just reopened the very loophole the Pickton case had so painfully exposed. But the court was clear. This doesn't mean mass murderers will just walk free after 25 years. It simply means they have the right to apply for a parole. The Parole Board of Canada would still have to decide if releasing them poses any risk to the public. For someone like Robert Pickton, the chance of actually getting parole is practically zero. But the possibility of parole, that tiny glimmer of hope, must exist. The court ruled that Canadian justice, even for the worst of the worst, can't be a system of pure vengeance. And so, the legal pendulum swung back. The law created in response to Robert Pickton's crimes was dismantled by a case that came a decade later. Today, Canada is back to where it was before 2011. A life sentence for murder carries a 25-year parole ineligibility period, regardless of the number of victims. The Pickton case forced a massive change, but the Canadian Constitution ultimately forced it back. On the afternoon of December 27, 2022, Ontario Provincial Police Constable Greg Piershala was just doing his job. The 28-year-old officer, who had just passed his probationary period that very morning, was responding to a routine call about a car in a ditch. When he arrived, he was ambushed and murdered. The grief was immense, but as details emerged about one of the people charged with his murder, that shock turned into white-hot rage. The man, Randall Mackenzie, was out on bail for previous charges, including assaulting a police officer and firearms offenses. A warrant was already out for his arrest because he'd skipped a court date. Yet, he was free. Free to, as the OPP commissioner put it, take the life of an innocent officer. Commissioner Thomas Carrake's words were blunt. The murder of Constable Greg was preventable. That sentiment became a rallying cry. Ontario's Premier, Doug Ford, declared, "Enough is enough," blaming what he called the revolving door of violent criminals caused by our country's failed bail system. Within weeks, the premiers of all 13 provinces and territories had sent a letter to the federal government demanding immediate bail reform. The public was asking a simple question. Why are people with a history of violent crime, especially involving weapons, being released back onto the streets while they wait for trial? The perception was that the system was broken, prioritizing the rights of the accused over public safety. To understand the change that followed, you have to understand a core principle of Canada's bail system, the presumption of innocence. This means an accused person has a right not to be denied reasonable bail without just cause. Basically, the default position is to grant release. It's the prosecutor's job to convince a judge to keep someone in custody. The onus, or burden of proof, is on the Crown. But for years, there had been tension around this. In 2019, Bill C-75 was passed to make it easier for people accused of nonviolent crimes to get bail, hoping to reduce the number of people in pretrial custody, especially from marginalized communities. But critics argued the bill went too far, creating a catch-and-release system even for violent offenders. The murder of Constable Piershala turned that simmering frustration into a political inferno. The narrative was powerful and simple. A violent offender, out on bail, killed a cop. The system had failed. The federal government responded swiftly. In May 2023, they introduced Bill C-48, which became law on January 4, 2024. Its goal was to make it much harder for repeat violent offenders to get bail. It did this by expanding something called a reverse onus. Remember how the Crown usually has to prove why someone shouldn't get bail? A reverse onus flips that entirely. The accused person now has to prove to the court why they should be released. Bill C-48 created this reverse onus for people charged with a violent offense involving a weapon who have a similar conviction in the last 5 years. Had this law been in place, Randall Mackenzie would have faced a much higher bar for release. He would have had to prove he wasn't a threat, a task he likely would have failed. This change wasn't without controversy. Civil liberties groups argued that expanding the reverse onus would lead to more people being jailed before trial, undermining the principle of innocent until proven guilty and worsening the over-incarceration of marginalized communities. They argued the real problem wasn't the law, but a lack of resources to handle bail hearings properly. Despite these concerns, the pressure after Constable Piershala's murder was overwhelming. The bill passed with unanimous consent. It was a hard swing of the pendulum back toward prioritizing public safety, driven by a tragedy that many felt was entirely preventable. Before the battles over Pickton and Piershala, another controversial legal provision was at the center of a long debate in Canada. It was known as the Faint Hope Clause, and getting rid of it marked a major shift in Canadian justice. So what was it? Officially, it was Section 745.6 of the Criminal Code, introduced back in 1976, the same year Canada abolished the death penalty. With capital punishment gone, first-degree murder now meant a mandatory life sentence with no parole for 25 years. The Faint Hope Clause was created as an incentive. It let offenders serving these long sentences apply for an early parole hearing after serving just 15 years. The idea was to encourage rehabilitation. It gave lifers a faint hope that if they demonstrated profound change, they might get an earlier shot at parole. The process was tough. An inmate had to convince a judge their application had a chance, and if they did, a jury would hear the case. That jury didn't grant parole. They just decided if the 25-year period could be shortened. The final decision was still up to the National Parole Board. For years, the clause operated quietly. But then came Clifford Olson, one of Canada's most sadistic serial killers, who murdered 11 children and teens in the early 1980s. In 1997, after 15 years, Olson applied for a hearing under the Faint Hope Clause. The public was horrified. The idea that a monster like Olson could even ask for a sentence reduction caused a massive outcry. His application was rejected, but the damage was done. The clause was now seen as a loophole for killers to get a deal. This sentiment fueled the tough-on-crime agenda that gained steam in the 2000s. The Faint Hope Clause was framed as a soft-on-crime relic. In 2011, the same year the Pickton-inspired law was passed, the government officially abolished the Faint Hope Clause with the serious time for the most serious crime act. The change was not retroactive, meaning offenders convicted before 2011 could still apply. But for anyone who committed murder after that date, the hope was extinguished. Abolishing this clause was a pivotal moment. It signaled a move away from a system that balanced punishment with rehabilitation toward one that prioritized denunciation and incapacitation for violent crimes. The Faint Hope Clause, born in an era of rehabilitation, couldn't survive in this new climate. The legal system is a complex machine, constantly being tweaked and rebuilt in the wake of human tragedy. As we've seen, one crime can change everything. If you find this deep dive into Canadian law and its evolution fascinating, Make sure you subscribe and hit that notification bell so you don't miss our next exploration into the cases that shape our world. The stories of Robert Pickton, Constable Greg Piers-Chawla, and the Faint Hope Clause reveal a Canadian legal system in a constant state of tension. It's a system caught in a perpetual tug-of-war. On one side, you have the raw, public demand for retribution. When a crime shocks the nation, the cry for tougher laws and longer sentences is overwhelming. We saw this with the law allowing stacked sentences after Pickton and the swift bail reforms after the death of Constable Piers-Chawla. These were laws written in response to outrage. On the other side stands the Canadian Charter of Rights and Freedoms. It's the constitutional backstop that insists even the most hated offender has basic rights. It's why the Supreme Court struck down stacked sentences, arguing that a sentence with zero hope is cruel. This creates a dynamic where law is pushed and pulled by competing forces. The immediate horror of a specific crime versus the long-term principles of constitutional law. What these cases show us is that law is not static. It's a living thing scarred by tragedy and reshaped by the public's demand for safety. Yet, it's also tethered to a constitutional foundation that resists changes driven purely by emotion. The balance between public safety, the rights of the accused, and the ultimate purpose of punishment is never permanently settled. It's debated in Parliament, argued in courtrooms, and redefined by the next unthinkable crime that forces the country once again to ask, what is justice and what price is high enough?